The courtroom smelled like old wood and institutional carpet cleaner, and Priscilla Adaze Monroe sat at the plaintiff's table with a manila folder, a legal pad covered in her own handwriting, and no attorney beside her. She had arranged her documents carefully, the way her father had taught her to organize anything important, in chronological order, labeled with sticky tabs, cross-referenced where necessary. Her hands were steady. Her back was straight. Her expression, she hoped, gave nothing away about the terror she was managing in her chest. Across the aisle, her husband of 11 years, Broderick James Monroe, sat with his attorney, a man named Clifton Haas, who had the practiced ease of someone who had won so many courtroom battles that losing had become theoretically possible, but practically inconceivable. Broderick was wearing a new suit, charcoal gray, expensive. He looked relaxed in the way men look relaxed when they believe the outcome is already decided in their favor. He had barely glanced at Priscilla when she came in. The case before Judge Wanda Okafor this morning was the final hearing for the dissolution of their marriage. Property division, spousal support, the distribution of 11 years of shared life into two separate piles. It should have been handled months ago, but Broderick's legal team had delayed and maneuvered and filed motions that accomplished nothing except running out Priscilla's ability to keep paying for representation. Her attorney had withdrawn from the case 8 weeks ago after Priscilla's retainer ran dry, and she had no way to replenish it. Broderick's strategy was working exactly as designed, and he had done this deliberately. Priscilla understood that now with a clarity she wished she had possessed earlier. Broderick had controlled their finances throughout the marriage with such completeness that when she finally found the courage to leave, she had almost nothing in her own name. The joint accounts had been drained in the weeks between her filing and the court freezing their assets. The investment accounts, which existed in structures she had not fully understood because Broderick had always handled the money, contained less than a third of what they should have held. Her attorney had raised these issues in early hearings, but the complex paper trail Broderick's financial advisors had created made proving dissipation a lengthy and expensive undertaking. Expensive. Which was how Broderick had eventually run her out of representation. Now here she was, pro se, representing herself in a divorce case against a man with a partner track attorney and 3 years of financial preparation on his side. Clifton Haas noticed her sitting alone at the plaintiff's table and said something quietly to Broderick. Broderick glanced over, and something crossed his face, not quite a smile. Something worse, satisfaction. "Your counsel isn't here?" Clifton asked, his voice carrying that particular courtroom projection that made even casual remarks sound official. "I am representing myself," Priscilla said. Clifton nodded slowly, the nod of a man who had already won. Broderick leaned back in his chair and crossed his ankle over his knee, the body language of a man settling in to watch something he expected to enjoy. Then Broderick said, loudly enough for the court reporter and the bailiff and anyone else present to hear clearly, "She couldn't afford one." He laughed, short and contemptuous, and Clifton did not tell him to stop. Priscilla looked down at her legal pad and did not react. She made a small note in the margin of her first page. 10:04 a.m. Respondent makes derogatory comment plaintiff's pro SE status. Loud enough for court to hear, she would use it when the time came. What Broderick did not know, what he had no way of knowing because Priscilla had told no one, not her friends, not her sister, not anyone in their shared social circle, was that her father was in the building, had been in the building since 9:15 that morning, was at this exact moment standing outside the courtroom doors in the hallway, her reviewing his own notes. Her father, Reginald Adais Osei, was 71 years old. He had been born in Accra, Ghana, come to the United States at 24 on an academic scholarship, and spent the subsequent 4 decades becoming one of the most respected family law attorneys in the state of North Carolina. He had argued before the state Supreme Court on 7 occasions. He had won 6 of them. He had taught family law as an adjunct professor at UNC for 15 years. He had mentored dozens of attorneys who now practiced across the Southeast. He had retired from active practice 3 years ago due to a mild heart condition, but his license remained current because Reginald Osei was not the kind of man who gave up the tools of his life's work while he still drew breath. When Priscilla had finally called her father 6 weeks ago, A breaking down on the phone at 11 at night after her attorney had informed her of the withdrawal. She had been prepared for sympathy and advice. She had not been prepared for what her father actually said, which was, "Tell me everything, from the beginning, and leave nothing out. I will be there on Thursday." Priscilla had protested. His heart, the travel, he was retired. Her father had said, "Priscilla Adaise, you are my daughter, and that man has spent 3 years trying to make sure you have nothing. I did not spend 40 years practicing law to stand by while my child is devoured by someone who thinks the absence of money means the absence of justice. I will be there on Thursday." He had been there on Thursday. He had reviewed every document, every filing, every motion, every financial record Priscilla had managed to gather. He had contacted 2 former colleagues who were still in active practice to consult on specific questions. He had filed the paperwork to enter his appearance as co-counsel with Priscilla, who would remain technically pro se since his appearance would be as a retired attorney assisting, but whose case was now being built and argued by a man who had spent 4 decades doing exactly this. He had told Priscilla not to tell anyone, not because secrecy was strictly necessary, but because Reginald Osei, who had spent a career reading people in courtrooms, wanted to walk through that door at the right moment. He wanted Broderick and his attorney to believe, completely and without any reservation, that they were about to dismantle an unrepresented woman. He wanted them relaxed. He wanted them careless. He wanted them to have made their decisions about how to proceed based on the assumption that there was no one in that courtroom who truly knew what they were doing. Comfortable opponents made mistakes, and Broderick and Clifton Haas had already made several. Now, if you are already gripped by this story, if you can feel Priscilla's quiet courage, and you are desperate to know what happens when that courtroom door opens and her father walks through it, then stop right now and hit that subscribe button. Here is something most people watching right now do not want to think about. Over 70% of the people watching Philly Folktales right now have never subscribed to this channel. You come back video after video, you feel every emotion, you carry these characters with you, watch, and then you leave without joining the community that makes all of this possible. Do not be one of those people anymore. Subscribe right now, smash that like button, and drop a comment telling me where you are watching from. Atlanta, New York, Houston, London, Lagos, Amsterdam. Wherever you are in this world, I need to know you are here. Because what happens next in that courtroom is going to make you believe in justice all over again. Judge Wanda Okafor entered at 10:12, and the room rose. She was a black woman in her mid-50s with silver-streaked natural hair and reading glasses perched on her nose that she moved with practiced efficiency, on and off and on again, as she moved between the case file and the people before her. She had been on the family court bench for 18 years, and there was nothing in this room she had not seen, no trick, no manipulation, no abusive process that could surprise her. She settled in, reviewed the file briefly, and looked at the plaintiff's table. "Mrs. Monroe, I see you are appearing pro se today. Is that correct?" "Yes, Your Honor. I am representing myself with the assistance of co-counsel who will be joining us momentarily." "Co-counsel?" Clifton Haas's eyebrows rose slightly. Broderick's ankle came down from his knee. The casual posture adjusted, just slightly. "We will proceed when co-counsel arrives," Judge Okafor said. "We have time." She looked at Broderick's table with the particular measuring expression of a judge who had already read the file thoroughly and formed preliminary impressions. "Mr. Haas, I have reviewed your most recent motion to expedite. I denied it this morning. We will be giving the plaintiff's case full consideration today, however long that takes." "Of course, Your Honor," Clifton said smoothly. At 10:18, the courtroom door opened. Reginald Osei was not a large man. He was perhaps 5'8", with the careful posture of someone who had spent decades in rooms where bearing mattered. He was impeccably dressed in a dark navy suit with a pocket square that precisely matched his tie. His hair was white, his skin the deep brown of old mahogany, his face carrying the particular authority of a man who had earned everything that was owed to him. He carried a leather briefcase that was old enough to be an antique and well-maintained enough to be a statement. He walked with a slight cane, and not from frailty but from a hip replacement 2 years ago, and he carried it with the same ease he carried everything. He walked to the plaintiff's table, set his briefcase down, Benin kissed his daughter on the top of her head with a tenderness that was entirely at odds with the formal setting, and then turned to face the bench. "Good morning, Your Honor. I am Reginald Osei. I have filed an entry of appearance as co-counsel for the plaintiff, Priscilla Monroe. I apologize for my slight lateness." Judge Okafor looked at him over her reading glasses with an expression that was unreadable. Then she looked at the filing before her. Then she looked at Reginald again. "Mr. Osei," she said carefully, "are you the Reginald Osei who argued Whitfield versus Whitfield before the North Carolina Supreme Court in 2009? "Among others, yes. And Your Honor, I clerked for Judge Harriman when that case was argued," Judge Okafor said. "It was masterful work." She paused. "Welcome to my courtroom, Mr. Osei." Clifton Haas had gone very still. His pen, which had been making idle marks on his legal pad, was no longer moving. He was studying Reginald with the focused attention of a man rapidly recalculating everything he thought he knew about this case. Broderick leaned over and whispered something urgent to Clifton. Clifton held up a hand without turning, the gesture of an attorney managing a client who did not understand yet what was happening. Then Clifton leaned back, and for the first time since Priscilla had walked into this courtroom, his expression was not that of a man who had already won. Priscilla kept her eyes on her notes. She did not look at Broderick. She did not smile. But somewhere in her chest, underneath the fear and the exhaustion and the weight of everything the past 3 years had cost her, something warm and certain settled into place. Her father had arrived, and everything was about to change. Reginald took a seat beside Priscilla, opened his briefcase with quiet efficiency, and arranged his documents with the practiced movements of someone who had done this thousands of times. He did not hurry. He did not perform confidence. He simply was confident in the way that comes from decades of absolute mastery. He leaned close to Priscilla and said in a low voice, "Breathe. We have everything we need." Judge Okafor called the proceedings to order. "We are here for the final dissolution hearing in Monroe versus Monroe. Given the change in the plaintiff's representation status, and I am going to allow opening statements before we proceed to the substantive matters. Mr. Haas, you may proceed." Clifton stood and delivered the argument he had clearly prepared for an audience of one, a judge who would hear it unchallenged because the woman across the aisle had no one to push back. He painted Priscilla as a wife who had been generously provided for during the marriage, who had chosen not to pursue her own career while enjoying the financial benefits of Broderick's success, and who was now seeking to extract a disproportionate share of assets in a marriage that had lasted 11 years. He argued that the prenuptial agreement they had signed should govern the distribution of assets, limiting Priscilla to a specific set of provisions that represented a fraction of the marital estate. He spoke smoothly and with authority. And if you had walked into the courtroom without knowing anything about the case, he might have been persuasive. But Reginald had read that prenuptial agreement 17 times. He had read every financial document Priscilla had been able to gather. He had consulted with a forensic accountant colleague who had reviewed the asset documentation and provided a written analysis. And he had researched Clifton Haas specifically, reading every publicly available record of his cases, understanding his strategies and the arguments he tended to make. When Clifton sat down and Reginald rose, the room's energy shifted. There is a quality to genuine expertise that is immediately recognizable, an economy of movement, a precision of language, a complete absence of wasted words. Reginald Osei spoke the way master craftsmen work, with exact and purposeful strokes. "Your Honor," Reginald began, "opposing counsel has just delivered what I am sure seemed to him like a comprehensive argument. It was in fact a carefully constructed narrative designed to obscure 3 distinct categories of misconduct. I intend to demonstrate each of them with documentation and, where appropriate, expert analysis. When we are finished, the court will have a clear picture not only of what Mrs. Monroe is owed under Georgia law, but of why the prenuptial agreement the respondent is relying upon should be found unenforceable in significant respects." Clifton was on his feet. "Objection, Your Honor. Counsel is making claims in opening statement without establishing foundation." "This is an opening statement," Reginald said mildly, not looking at Clifton, but at the judge. "I am telling the court what I intend to prove. I will prove it." Judge Okafor nodded. "Continue, Mr. Osei." Reginald laid out three arguments with crystalline clarity. First, that the prenuptial agreement contained provisions that failed to meet George's legal standards for enforceability, specifically because Priscilla had been given the document 4 days before the wedding with no independent counsel and had signed under what amounted to duress. Second, that Broderick had committed deliberate dissipation of marital assets in the period between Priscilla's filing and the court's asset freeze, moving money through a series of accounts in a pattern that the forensic accountant's analysis showed could not be explained as ordinary business activity. Third, that Broderick had actively hidden an investment account that had not been disclosed in any of his financial affidavits. That third point landed like a stone in still water. Clifton went very still. Broderick, beside him, turned an ugly shade of red that Priscilla recognized. She had seen that particular color on his face before. It was the color of being caught. "Your Honor," Reginald continued, "I have here a forensic accounting report prepared by Dr. Aurelia Dempsey of Dempsey Financial Forensics, whose credentials and methodology I can provide to the court. The report identifies an investment account held in the respondent's sole name at a financial institution not mentioned in any of his disclosures. The account currently holds approximately $240,000, accumulated over the course of this marriage using income that was marital property." He produced the report and handed copies to the court clerk and to Clifton Haas simultaneously. The court clerk accepted hers with professional neutrality. Clifton accepted his and opened it to the account documentation, and the color of his face changed. Broderick grabbed Clifton's arm and whispered furiously. Clifton put his hand on Broderick's wrist in the gesture of an attorney managing a client who needs to calm down immediately or make things significantly worse. Judge Okafor was reading the report with careful attention. She had put her reading glasses on and was not hurrying. When she looked up, she looked at Broderick's table, and the expression on her face was not one Clifton Haas wanted to see directed at his client. "Mr. Haas," she said, "I assume you will want time to review this documentation before we proceed." "Yes, Your Honor, that would be." "I am going to give you 15 minutes, Judge Okafor said, "and I want to be clear that the discovery violations implied by this report are something this court takes extremely seriously. If there are assets that have not been disclosed in the respondent's financial affidavits, that is a matter with consequences beyond the scope of today's proceeding." 15 minutes. Reginald sat down, folded his hands on his legal pad, and waited with the patience of a man who had learned 40 years ago that courtrooms moved at their own rhythm and fighting it wasted energy needed for other things. Priscilla looked at her father. "Are you all right?" she asked quietly, because his heart condition was always in her mind. "Antoine, I am perfectly fine," Reginald said. "Are you all right?" "I think so. That account, how did you find it?" "The forensic accountant," Reginald said simply. "Broderick hid it, but he did not hide it from someone who does this for a living. The deposits show a regular pattern consistent with systematic diversion from his business accounts. It has been building for 4 years." 4 years. Priscilla thought about that. Broderick had been planning this for 4 years, had been setting aside money, hiding it, building his exit while she was still believing in their marriage. "He was always going to do this," she said. It was not quite a question. "It appears so," Reginald said, without adding commentary because he was her father, and he understood that this particular pain required acknowledgement, not analysis. When the 15 minutes were up and Clifton returned to the table from the brief conversation with Broderick in the hallway, something had changed. Not dramatically, not in any way that would be visible to a casual observer, but Priscilla had spent 11 years reading subtle shifts in Broderick's bearing, and she could see it clearly. He was not relaxed anymore. He was not the man who had laughed at her for having no lawyer that morning. He was a man who understood, possibly for the first time, that he had significantly miscalculated. The proceedings resumed. Reginald methodically addressed each of his 3 points with documentation and precision. On the prenuptial agreement, he cited specific Georgia case law establishing the standards for enforceability and walked the court through the timeline of how Priscilla had received the document. He had obtained a statement from the wedding venue confirming the rehearsal dinner date, establishing that the document had indeed been presented with the wedding 4 days away, family already in town, vendors contracted, no realistic ability to walk away. The standard, Reginald told the court, is not merely whether she signed voluntarily in the technical sense of not being physically coerced. The standard is whether she had meaningful opportunity to consult with independent counsel and make an informed decision. The evidence shows she did not. The agreement should be set aside, Clifton argued back, citing different case law. Reginald distinguished each citation with the ease of someone who had literally read the cases as they were decided, who had in some instances been in the room when the standards were argued. Judge Okafor asked pointed questions of both sides and made careful notes. On the asset dissipation, Reginald walked through Dr. Dempsey's analysis of the transactions that had moved money out of accessible accounts in the weeks between Priscilla's filing and the court freeze. Each transaction had an innocent-seeming explanation on its face, but the pattern, the timing, the destinations, all painted a picture that was difficult to explain innocently. Clifton challenged the forensic accountant's methodology. Reginald, who had spent an afternoon with Dr. Dempsey specifically preparing for this challenge, fully addressed each objection with the methodological detail of someone who had done their homework. And on the hidden account, there was very little Clifton could say. The account existed. It had not been disclosed. Those were facts. By the time the morning session broke for lunch, the dynamic in the courtroom had transformed completely. The case that Clifton Haas had arrived at expecting to win on procedural dominance had become a genuine legal contest, and one in which the ground had shifted substantially toward the plaintiff's side. During the break, Reginald and Priscilla sat in a small conference room the clerk had arranged for them. Reginald ate a sandwich he had packed with characteristic preparation. Priscilla could not eat. "You are doing well," her father told her. "When the judge asks you questions this afternoon, when answered directly and simply, do not elaborate beyond what is asked. Do not look at Broderick." "What do you think happens?" Priscilla asked. Reginald was quiet for a moment. "I think the prenuptial agreement has serious problems that Judge Okafor will want to address. I think the hidden account significantly changes the asset picture. I think Broderick's credibility with this judge is compromised, which matters in how she weighs his testimony this afternoon. I think you have a very different day ahead of you than you woke up expecting." Priscilla felt tears threaten and blinked them back. "I thought I was going to lose everything." "I know," Reginald said. "That is what he wanted you to think. It is easier to control people when they believe they have no power." He reached across the table and put his hand over hers briefly, a gesture so familiar from her childhood that it made her feel simultaneously 17 and 38. "Your mother and I did not raise you to have nothing," he said, and Broderick Monroe did not understand who he was dealing with. The afternoon session began with Broderick's testimony, and it was during this portion of the proceedings that Priscilla understood fully what her father had meant about comfortable opponents making mistakes. Broderick had prepared for a morning of watching his attorney dismantle an unrepresented woman's disorganized case. He had not prepared for an afternoon of being cross-examined by a man who had spent 40 years doing exactly this. Reginald's cross-examination of Broderick was a lesson in controlled demolition. He did not raise his voice. He did not become combative. He asked questions in a sequence so carefully constructed that each answer built the next trap. And by the time Broderick realized where a line of questioning was going, he had already provided the answer that made escape impossible. On the hidden account, Broderick tried to claim it was a personal account opened before the marriage that he had continued independently. Reginald produced deposit records showing contributions from an account that received Broderick's business income during the marriage. He asked Broderick in precise sequence to confirm the account number of his business account, to confirm that account's routing number, to confirm that he was the sole authorized user, and then to explain why the deposit trail in the hidden account matched perfectly with transactions from that business account on specific dates. Broderick looked at Clifton. Clifton looked at his legal pad. "You may answer the question," Judge Okafor said. Broderick's answer was evasive. Reginald noted the evasion without comment and moved on, allowing the evasion to sit in the court record like a stone. On the prenuptial agreement, Reginald asked Broderick to describe the circumstances under which Priscilla had received the document. Broderick said they had discussed it together, and she had had plenty of time to review it. Reginald produced a text message exchange from 4 days before the wedding, in which Broderick had sent Priscilla the document attached to a message saying, "Need you to sign before Saturday. Lawyer says we have to have this in place." The text was time-stamped. Saturday was the wedding day. Did you advise your then fiancée to seek independent legal counsel before signing this agreement? Reginald asked. She could have gotten a lawyer if she wanted one. Did you advise her to? Silence. Mr. Monroe, the question is simple. Did you at any point before your wedding advise Priscilla that she should consult an attorney before signing the prenuptial agreement you sent her 4 days before the ceremony? I did not think she needed one. But you had one. A pause. Yes. Your attorney who drafted this agreement reviewed it with you, explaining each provision and its implications? Yes. And yet you did not think the woman who would be bound by these same provisions deserved the same level of explanation and counsel. It was not quite a question, which was why Clifton's objection that it was argumentative was technically valid. But the point had been made, and it was in the record, and Judge Okafor had heard it, and her expression said that she had heard it and understood exactly what it meant. Broderick tried to recover lost ground when Clifton conducted his redirect examination. He described Priscilla as someone who had been uninterested in the financial details of their marriage, who had left all financial decisions to him because she preferred it that way, who had lived comfortably on his income while pursuing interests that did not generate revenue. He framed her as a dependent spouse who had benefited substantially from his success and was now attempting to take more than her fair share in the dissolution. It was not an entirely false picture. Priscilla had not worked full-time since early in their marriage. She had managed their home, been the primary caretaker during a difficult health period Broderick had not mentioned in his testimony, supported his career advancement in ways that were real but invisible on a balance sheet. She had not been financially sophisticated in the way Broderick was. She had trusted him with the money because he had positioned himself as the expert, and she had believed, for a long time, that his expertise was deployed in service of their shared life. When Priscilla took the stand, Reginald walked her through those invisible contributions with methodical care. The 2 years she had been Broderick's primary caregiver following a serious back surgery that had required multiple procedures and extended rehabilitation. And the client dinners she had organized and hosted that Broderick's colleagues still mentioned. The move she had managed entirely, from packing their previous home to establishing their current one, while Broderick traveled for work. The continuing education classes she had put on hold 3 times because Broderick's career needed support at critical moments. None of it had appeared in any of Broderick's filings. He had presented a marriage in which Priscilla had been a pleasant but financially irrelevant presence. Reginald restored the fuller picture, and as Priscilla answered each question, she watched Judge Okafor make notes with the focused attention of someone who was hearing a version of events that changed the calculus significantly. Now Clifton's cross-examination of Priscilla was aggressive in the way that worked on unrepresented witnesses unfamiliar with courtroom dynamics. He asked rapid questions designed to confuse, implied contradictions between her testimony and earlier filings, and characterized her recollections as conveniently selective. But Priscilla had spent 2 weeks preparing for this with her father. She answered directly and simply, exactly as he had instructed. When Clifton mischaracterized something she had said, she corrected the mischaracterization calmly. When he implied she had fabricated the timeline of the prenuptial agreement, she referenced the text message exhibit already in evidence. When he pushed her on her financial dependence, she acknowledged it without shame and explained its context without defensiveness. She did not look at Broderick. When Clifton finished and Priscilla returned to her seat, Reginald touched her arm briefly. He did not need to say anything. She had done well, and they both knew it. Judge Okafor called a brief recess before closing arguments, and Priscilla and Reginald sat in the conference room again. This time Priscilla ate half her sandwich. He looked scared, she said. She meant Broderick, though she had tried not to look at him. He understood, probably around 11 this morning, that he had made a serious tactical error in believing you had no resources, Reginald said. He built his entire strategy on your isolation. When that assumption proved wrong, everything else became less certain. What happens now? Closing arguments. Then Judge Okafor will likely take the matter under advisement rather than ruling today. A case this complex, with the evidentiary issues around the hidden account and the prenuptial challenge, she will want to write a considered order, perhaps 2 to 4 weeks. And the hidden account? If she finds he deliberately hid it, then in addition to including it in the marital estate, She has discretion to sanction him for the discovery violation, and she may refer the matter to the state bar given that his legal team was presumably aware of it. Discovery violations involving concealed assets are serious, Priscilla. They have consequences. Consequences. It was a word Broderick had never seemed to believe applied to him. Closing arguments were the final act of the day. One of Clifton's was technically accomplished but perceptibly diminished from the confident performance of that morning. He was arguing a case that had not gone the way he planned, and the best attorneys in that situation adapted their arguments to the evidence that had actually come in rather than the evidence they had expected to dominate. Clifton was good enough to do this, but the adjustment was visible. Reginald's closing was quiet and devastating. He organized the day's evidence into a narrative that required no embellishment, because the facts were sufficient. He reminded the court of the text message establishing the prenuptial agreement's 4-day window. He walked through the forensic accountant's documentation of the hidden account and the asset dissipation. He cited the specific Georgia Code sections in case law that supported his arguments on each point, and he concluded with something that was neither dramatic nor sentimental, but landed with the weight of absolute truth. Your Honor, Mrs. Monroe came into this courtroom this morning without an attorney because her husband's strategy over 3 years has been to drain her of the resources that would allow her adequate representation. He believed that an unrepresented spouse would be easier to defeat, and he was not wrong about the typical outcome. What he did not account for was that Georgia law does not require a lawyer to deliver justice. What it requires is evidence, legal argument, and a judge committed to applying the law correctly. We have provided the first two, and we trust the court to provide the third. Judge Okafor was quiet for a moment after Reginald sat down. She looked at her notes, then at both tables. This court will take the matter under advisement, she said. I expect to issue a written order within 3 weeks. I want to say for the record that this has been one of the more thoroughly prepared plaintiff's presentations I have seen in a case of this type. The evidentiary issues raised, particularly regarding the asset disclosure, will require careful consideration. Court is adjourned. The bailiff called the room to rise. As Judge Okafor gathered her materials and left the bench, Reginald began organizing his documents with the same unhurried efficiency with which he had arranged them that morning. Across the aisle, Broderick and Clifton were in urgent, quiet conversation. Broderick's face had none of the morning's satisfaction. He glanced at Priscilla once briefly and looked away. Priscilla looked at her father. Thank you, she said, and the word carried the weight of everything it was trying to hold. Reginald looked up from his papers and studied his daughter for a moment. You held yourself with extraordinary dignity today, he said, not just because of the circumstances, because that is who you are. Do not forget that. 3 weeks later, Judge Okafor's written order arrived. Priscilla was at work when her phone buzzed with her father's call. Are you somewhere you can sit down? He asked. Yes. The prenuptial agreement has been found unenforceable. Judge Okafor accepted our argument on the timeline and the lack of independent counsel. The hidden account has been included in the marital estate. She found that the asset dissipation was intentional and has sanctioned Broderick $100,000 payable to you as a penalty. And she has referred the discovery violation to the state bar for investigation of Clifton Haas. Priscilla sat very still with the phone against her ear. Total settlement to you, including your share of the marital estate without the prenup limitations, the hidden account properly distributed, and the sanction comes to approximately $480,000, plus spousal support of $3,000 monthly for 5 years. The number was so far from what Broderick had wanted her to accept, so far from what she would have walked away with had she sat alone at that table, that Priscilla could not immediately speak. Ifranz, the judge, also noted in her order that the court found Mrs. Monroe's testimony to be credible and Mr. Monroe's to be evasive on several material points. Reginald continued. She wanted that in the record. Priscilla found her voice. Daddy. Yes? You saved my life. Reginald was quiet for a moment. No, you saved your life by calling me, by refusing to just accept what he told you that you were worth. I just held the door open. In the weeks after the order, Priscilla began the work of rebuilding. She found an apartment she loved in a neighborhood close to her sister. She enrolled in the continuing education program she had deferred 3 times during her marriage, working toward the business administration certification she had always wanted. She had money now, real money, were her fair share of a marriage she had genuinely invested in, and she was thoughtful and deliberate about how she used it. Broderick's attorney, Clifton Haas, received a formal notice of state bar investigation 6 weeks after the order. The outcome of that process was still pending, but the investigation itself was consequential, the kind of professional exposure that followed an attorney through their career, regardless of the final determination. Broderick had to liquidate certain assets to pay the settlement and the sanction, assets he had been protecting as the core of his financial security. The comfortable position he had worked 3 years to engineer, with most of the marital wealth retained, while Priscilla walked away with the minimum the prenup allowed, had become the opposite of what he planned. And it had happened because of the single assumption he had made at the foundation of his entire strategy, that she would have no one. One evening in early fall, about 2 months after the order, Priscilla called her father to give him an update on her progress. The apartment was arranged. The classes were going well. She felt, she told him, like herself again for the first time in years. Like the woman who had existed before the marriage had slowly convinced her that she was smaller than she was. "You were always that woman," Reginald said. "Broderick worked very hard to make you forget it. That is what controlling people do. They build architecture around you until you cannot see past the walls." "I saw past them eventually," Priscilla said. "You did. And then you called your father." A pause that contained a smile, which, I want to note, you could have done considerably earlier. Priscilla laughed. A real laugh, full and unguarded. "I know. I thought I had to handle it myself." "You do not always have to handle things alone," Reginald said. "That is not strength. Strength is knowing when to accept help, knowing when to call the people who love you and say, 'I need you. I cannot do this alone.'" "I know that now." "Good. Hold on to it." In November, Priscilla attended the graduation ceremony for her first completed certification course. Her father drove up from his home 3 hours away to attend. Celestine, his wife and Priscilla's mother, came with him, and they sat in the audience together watching their daughter walk across the stage to receive her certificate. Afterward, over dinner at a restaurant Priscilla had chosen, Reginald raised his glass and said, "To Priscilla Adaez Monroe, who walked into a courtroom against impossible odds, conducted herself with grace under tremendous pressure, and reminded a great many people that the absence of money does not mean the absence of justice." Priscilla's mother reached across the table and squeezed her hand. "We are so proud of you." "The court was proud of me," Priscilla said, smiling. "My husband's attorney less so." Her father laughed, and it was a good laugh. The laugh of a man who had spent a lifetime in courtrooms and understood the particular satisfaction of a case that went the way justice required. A year after the hearing, Priscilla was working full-time in a position that used her organizational skills and developing business knowledge, earning a salary that was hers, controlled by no one else, but deposited into an account only she could access. She was finishing her second certification course. She had made new friends, reconnected with old ones, rebuilt the social landscape that Broderick had gradually narrowed during their marriage. She thought about Broderick sometimes, but with decreasing frequency and decreasing intensity. Not with hatred, which required more energy than he deserved, and not with the consuming grief of the early years, but with something close to indifference. He had been a chapter, a difficult, damaging chapter, but not the book. She thought about her father more, about what it had meant to have him walk through that door. Not just the legal expertise, though that had been decisive, but the message it carried, that she was not alone. That her family saw her value even when her husband had worked so hard to convince her otherwise. That love, the real and lasting kind, showed up when it mattered. She called him every Sunday. They talked for an hour, sometimes more, about everything and nothing. About her week in his garden and her mother's ongoing campaign to learn watercolor painting and Priscilla's progress in her classes. About the cases he was following in the legal news and the ones she had read about and wanted to understand better. He was 71 years old with a repaired hip and a careful heart, and he had driven 3 hours, walked into a courtroom, and spent a day dismantling the architecture of a man who thought the absence of money meant the absence of justice. Priscilla knew she would spend the rest of her life grateful for it, Not in a way that felt like debt, but in the way you are grateful for the things that form you, that remind you of who you are and where you come from, that stand behind you when you walk into rooms that were designed to make you feel small. She had walked into that courtroom with nothing but a manila folder and a legal pad and the quiet secret of who was about to come through the door, and she had walked out with her life.